Well, it is a happy day, a day to be celebrated for sure. Matthew Ferman was convicted on one count of felony misconduct while in office and another count of assault and battery for his abuse of Jakar Williams during that traffic stop. There are a lot of things that we can go over, and I'll give you my thoughts about what went right, what went wrong, and what I think will ultimately happen. Let's talk about it. What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. Let me just say from the outset, Dennis Whitey did an amazing job. And if I had to judge who won this case, I think Ferman won this case. And I don't mean that because I'm happy about it. And I don't mean that because there wasn't an opportunity for the state to win. I genuinely mean that because I think the state really shit the bed on the trial. I really do. I think that they gave it away. I'll explain how I think they gave it away. But ultimately, Dennis Whitey's a really good lawyer. And if you get in trouble in the Wayne County area, I suggest you go hire him, because to humanize Matthew Ferman and eliminate 4 out of 6 charges, I think he probably saved his client some jail time. And I think he did as good as you can possibly do when Matthew Ferman is your client. All that said, we're just going to go out. WXYZ covered this extensively. We're just going to go out, look at their videos, and I'll give you some commentary along the way as the testimony unfolds. Let's check it out.
A Wayne County jury delivering a guilty verdict against a former Melvindale lieutenant. Thank you for joining us. I'm Glenda Lewis.
And I'm Simon Shakett. Matthew Ferman escaped 4 of the 6 charges against him, but could not dodge a 5-year felony or an assault and battery charge. The verdict means Ferman can no longer be a police officer, and it could even land him behind bars.
7 investigator Ross Jones brought Ferman's abuses to light more than a year ago, leading to these charges, his firing, and new leadership in the chief's office.
Ross was also in the courtroom today when that verdict came down.
With regard to Jakar Williams, how do you find the defendant Matthew Ferman? Guilty.
The notorious law enforcement career of Matthew Ferman came to an end in Judge Mark Slavin's courtroom today. The jury deliberated for about 2 hours before finding him guilty of misconduct in office, a 5-year felony, and assault and battery, a misdemeanor, over a 2024 police stop first revealed by 7 News Detroit.
Well, first of all, I want to thank you, bring this to light.
Melvindale Police Chief Chris Egan was in the courtroom throughout the trial and when the verdict was read today.
There's a new day in Melvindale. We do have new leadership. We have new standards. And quite honestly, it shocked the conscience of a lot of police officers besides the public.
Chief Egan and Assistant Chief Daryl Campbell took over the department after Ferman was charged last year. Ferman was fired in February.
I think what you saw in the videos hurt the profession. And what we have today with the jury's decision is closure. And this helps our profession.
Hands behind your back! You do it. He got me! He got me!
Ferman was convicted in the case involving Jakar Williams, who the lieutenant stopped for driving around traffic barricades. Ferman surprised many in the courtroom Wednesday when he took the stand in his own defense, calling his actions justified.
This jury deliberated, they listened to the instructions and applied them accordingly.
It wasn't all bad news for Ferman. On 4 of the 6 counts, he secured a not guilty verdict, including all the charges brought against him in the case involving Alicia Cook, the mother sitting in a parked car outside of her daughter's school when Ferman encountered her. He would ultimately tase her twice after she refused to supply her license or step out of her vehicle.
I don't know if this is a lesson learned type thing, but I think it's a chapter closed and a finality to law enforcement, and I think it's a good transition for him.
Ferman's attorney, Dennis Whitey, said his client has picked up farming since he was fired by the department. He awaits sentencing on May 29th. Melvindale's mayor, Nicole Shkira, a longtime defender of Ferman, was in the courtroom when the verdict was read. She declined comment. For the city, this has been a surreal week. Just 1 floor below, in the very same courthouse, the trial of the man accused of killing Melvindale officer Mohammed Saeed was taking place too. Today's verdict closes 1 chapter in the city's history, while another waits to be finished.
It's difficult when you sit through a case involving an officer that was killed, whether you know him or not, actually did know him, and then to come up and deal with an officer that hurt the citizens of Melvindale.
That is unacceptable in law enforcement. And that's why we are here, to make sure that those standards change.
Misconduct in office is a felony punishable by up to 5 years behind bars, but Furman could receive probation. He will learn his sentence on May 29th. I did speak with Alicia Cook by phone after the verdict was read. Even though the jury did not convict on any of the charges stemming from her case, she said she was thankful for their verdict and that Furman's law enforcement career is over.
Wow, trauma really all around.
For sure.
He's scheduled for another trial that was supposed to take place Monday.
Exactly.
Is that still happening?
Now that's no longer happening. He took a plea after he was found guilty. That was a 2021 case where he was charged with a number of things over stomping on a man's leg who just led police on a pursuit. He pled no contest to assault and battery. So now that's going to be, he'll be sentenced on that on May 29th, and we'll learn his sentence then.
All right, Roswell. Great work. Thank you so much.
Of course.
Mr. Ferman, please raise your right hand. Thank you. Do you solemnly swear or affirm that this testimony you're about to give in this matter, now pending before this court, will be the truth and nothing but the truth, so help you?
Yes, ma'am, I do.
Thank you.
Sir, you can have a seat there.
Thank you, Your Honor.
Once you've got yourself situated, if you can bring yourself in as close as you can to that red microphone without being uncomfortable, sir. And when you're all ready, if you can give us your name, please, sir.
Yes, Your Honor. My name is Matthew Ferman.
All right, thank you. Your witness, counsel.
Okay. Mr. Furman, prior to these incidents, were you employed?
Yes, sir.
And how were you so employed?
I was a police lieutenant with the Melvindale Police Department.
Okay. And what date were you hired by the Melvindale Police Department?
May 9th, 2012.
Okay. And you're hired as a patrol officer, is that correct?
Yes, sir, that's correct.
Okay. At some point in time, do you get promoted?
Yes, sir, several times.
Okay. What's the first promotion you received?
About 2 years in the job, I was promoted to corporal. In 2018, I was promoted to sergeant. And in 2024, I was promoted to lieutenant.
Okay. And so in the year of 2024, you were a lieutenant, correct?
Yes, sir, that's correct.
What were your responsibilities as a lieutenant?
I was administrative lieutenant. Due to short staffing, I did spend a lot of time working the road and assigned details, as well as administrative tasks. I was in charge of the road patrol division, the motor carrier, and the ordnance divisions.
Okay. And you said due to staffing shortages, you worked a lot of road duty. Is that answering calls and things of that nature?
Yes, sir, that's correct.
Okay. So it's fair to say, in addition to your administrative role, you were actually on the street?
That's correct.
Okay. There was also a discussion, I believe, earlier in testimony about a traffic detail. Do you remember that from
Yes, sir.
Officer Rahman? And tell the jury, what's the traffic detail?
So our city gets a lot of complaints from residents regarding different traffic issues. The day in question, I was actually working, Mr. Williams' traffic stop, I was working a traffic detail on Greenfield Road, and there was utility work on gas lines going on at that time for a number of weeks. Let me rein it back in.
Sure. Sure. Just tell them, what is the traffic detail program? What
Sure.
Is
So I'll remind you we're going to do this question and answer.
Oh, I understand.
Okay. All right.
Yeah.
Go ahead.
So traffic detail is an officer would go in and specifically work traffic enforcement, addressing traffic complaints and issues throughout the city.
Okay. And was that traffic program, would you answer calls as part of that traffic detail?
Yes, if needed, if there was a priority call, a serious call, domestic, a fight, something like that, you would break off the traffic detail and then you would head to back the other officers on whatever that situation was.
Okay. And did you work traffic detail?
Yes, I did.
Did you work it a lot, or?
I did.
Okay. In your career, how many traffic stops, approximately, if you can estimate, have you made?
It's hard to say, but conservatively, probably somewhere between 15 and 20,000 traffic stops.
Okay. And is that mainly through the traffic, or is that traffic and patrol?
That's traffic and patrol. On regular road patrol, if you're not on a call, you are expected to be proactive and also do traffic enforcement during your regular shift.
Okay. I'm going to take a step back. You went to the police academy, is that correct?
Yes, sir, that is correct.
Which police academy did you go to?
Washtenaw Community College.
And thereafter, you were hired by the Melvindale Police Department, is that correct?
That is correct.
And was there additional training once you were hired?
Yes, we had a 4-month field training officer program. So your first month on the job, you ride on day shift with a supervisor. Your next month, afternoons. Your next month, midnights. Then back to days for what they call a shadow phase, where you're kind of taking things over and your supervisor basically monitors you to make sure you're doing okay. After that, you're on a 1-year probationary period where they do monthly evaluations, and there's a lot of continuing training both within and from outside the department. Classes you're sent to, online training, in-person training.
Okay. And is all that training through MCOLS, or is it training outside of MCOLS?
No, there's a lot of training outside of MCOLS. One thing I was always interested in was, for example, auto theft related issues.
You've answered the question. Okay, I don't want to cut him off.
Oh, sorry.
Okay, fair enough. And so, yeah, and so when Deputy Chief Martinez testified earlier that the MCOLS record is just part of your training, you would agree with that, correct?
Absolutely.
So one thing that's happening here in the first couple minutes that you need to understand is that they're laying the groundwork for essentially what a day in the life of a police officer looks like, just in case the jury is sort of unaware. And one thing that you're going to notice right away is that the judge is having to step in and keep him from just narrating. Sometimes the prosecutor will not do that. Sometimes the prosecutor will let them talk. I would let them talk. But so as of right now, I would be doing the same thing the prosecutor's doing, which is nothing. But I think the prosecutor was not doing it for the reasons I was doing it. I think he just didn't do a very good job of objecting when he should have objected, because there's only one reason. We talked about this in the Ferman case. You let a witness talk and say whatever they want to say because you're hopeful that the jury will hate them, or you're hopeful that they'll say something that will trip them up that you'll be able to use against them. So with a guy like Ferman, I think Makepeace was kind of the opinion that if I let him talk, he's going to hang himself. The judge, though, is doing a really good job of managing. He's not being biased because he does it to both sides. That's different than what we saw in the Furman trial, where the judge was just a homer for the other side. This judge is doing a really good job of just sort of managing the way that, because Ferman is not directly responding to the questions, which means that he has a prepared statement that he's made, but the judge is noticing it and the judge is stopping it. But essentially the first couple minutes of this is just him building a record and a resume for the jury.
There's a lot of training that's not done through MCOLS, so it doesn't show up on those records, but it's still training.
Okay.
Just through other divisions.
Were you trained in the use of force?
Yes, sir.
Okay. And where did you receive that training?
In Police Academy.
Okay. Anywhere outside of the Police Academy, did you receive any training?
We did taser training, pepper spray training at the police station, firearms training at the police station.
Okay. So there was updated training through the Melvindale Police Department?
Yes, sir, that is correct.
And on July 20th of 2024, you were certified to carry the taser, correct?
Yes, sir.
Okay. Are you familiar with the Melvindale Police Department's arrest policy?
Yes.
Familiar with the taser policy, correct?
Yes.
There's also, I believe, a prisoner handling policy, correct?
Yes.
And are you expected to know those?
Yes. When you are on FTO, you're responsible for reading every department policy there is. And then thereafter, if policies are updated, as time goes on, everyone's given a copy. You're expected to review those and stay up on things as laws change and policies change.
Now, I know you stated you conducted about 15 to 20,000 stops over 12 plus years. What kinds of incidents have you experienced while on a traffic stop?
Essentially everything you could think of at this point. I will say 99.9% of traffic stops go smoothly and without incident, but I've been involved in chases. I've had my patrol car rammed. I've been punched, kicked, bitten, spit on, stomped, beaten, was dragged down the road a couple hundred feet by a car, you name it.
Okay. Well, you said you were, sometimes when you stop cars, they flee, they run, correct?
That is correct.
Which results in a pursuit, is that right?
Correct.
Okay. And I guess statistically, the more traffic stops you make, the more likely you are to encounter some of these bad things.
That is correct.
Fair enough. I'll withdraw it. Now, you brought up the issue with that you were drugged down the road on a traffic stop, correct?
That's correct.
Can you tell
I'm going to object at this point. I don't believe the court-required foundation that was discussed on the motion when they have been laid to go into this yet.
I'm asking about the incident, then the foundation for what the court has allowed me to. Okay, thanks.
You can tie it out.
Yeah, that's. Okay. Tell me what happened on that traffic stop.
So I initiated a traffic stop. I was working day shift on regular patrol, and I pulled over a vehicle that had a improper license plate on it. I made contact with the driver. He refused to provide identification. refused to provide paperwork, refused to provide his name, wouldn't give me any sort of information. And I was trying to talk him into turning the car off, handing me the keys. He refused to do that. And as we're conversing, he grabs my arm and just floors it and dragged me down the road a couple 100 feet. My uniform got shredded, my leather gear got torn up. Ended up at the hospital with fractured wrist and getting asphalt and glass and rocks and metal picked out of my skin throughout my body. I've still got scars. 10 years later, still have problems with my wrist, and that'll probably have the rest of my life. And I came very close to dying on that incident.
Do you, have you ever saw a video of that happening to you?
I have. We actually used it within the department as a training and review. After that happened, we were able to obtain surveillance from the refinery, which was along the road where it happened.
From the court's pretrial ruling, I'll admit that. Looking at that video, that's an accurate depiction of what happened, is that correct?
Yes, sir.
Were there any mistakes you made on that traffic stop that caused that to happen? Okay.
No.
So,
well, I guess I wasn't forceful enough, wasn't careful enough, and the suspect was able to grab a hold of my arm and just hit the gas.
Okay.
Now, one of the things that I'm curious about, now you just heard them argue, and I don't know if you caught that, but there's a thing called a motion in limine, and it is basically just a pretrial motion where one side will say, hey, we don't want the other side talking about this thing at trial. And so before there's a chance that it'll get introduced to the jury, the parties will sort of argue about whether or not that's admissible, it's relevant, whatever. He says that this incident with him being dragged down the road happened in 2015 or 2016. Keep in mind, Matthew Ferman was convicted. He pled guilty, actually, or pled no contest or something, to a charge back in 2019 where he was alleged to have assaulted a person inside a home, and there was allegations that he threw him down the stairs, and they ultimately fired him over that. But he withdrew his plea, he beat the criminal charge, and then beat the termination. And so I'm wondering whether there was ever an attempt by the prosecutor to be able to bring in that previous arrest and those previous charges. You ordinarily cannot use evidence of somebody's bad character, or what they call propensity evidence or prior bad acts evidence. And the rule is basically you can't say that because this person did something bad in 2019, they did this now because they have a bad character, and this prior thing that happened is evidence of that because that's what they did here too. You can only do that under certain exceptions. Well, one of those exceptions is called common plan or scheme, and the other exception is called intent, to prove that a person had an intent to do a particular thing. And keep in mind that one of the elements of misconduct in office, the one that's the major one and difficult to prove, is called corrupt intent. And so I don't know whether the prosecutor made an argument to try to get that prior arrest in, because he's basically saying, and he's going to continue to say, that the reason he conducts himself the way he does, with such a heightened presence, high sense of alert, sort of propensity to escalate immediately, is because he got dragged down the road in this car. And then later, he's got an arrest for assault 4 or 5 years later. And then it's just continued to escalate and escalate and escalate all of this time. So I would expect that the prosecutor tried to get that in so that he could prove that this guy has a history of doing this in a common plan or scheme. He talks to everybody the same way. He waits for them to do something that triggers a response in him so that he can justify using force on him. And, he started doing this, sure, after he got dragged down the road. I'm surprised that we didn't hear any evidence about that prior arrest, and I don't know why. And I think that if it wasn't allowed in, it's probably because the prosecutor did a poor job of arguing it. Because your case is you have to prove corrupt intent, and you have situation after situation after situation where this guy acts exactly the same way and the same exact thing happens, which means that he triggers the person, that person does something that gives him a justification to use force. That bad arrest would have been a good example of that having happened before and him being charged criminally as a result. He says that the reason this guy did this to him was because he wasn't forceful enough and didn't use enough control. We actually don't have any record of what was said. We don't know that Matthew Ferman didn't do exactly in that situation what he did in all the rest of these situations and started escalating for no reason, because we don't have the audio. They didn't have body cams. They didn't have dash cams. We don't have any idea what was actually said. And the defense did a really good job of humanizing Matthew Ferman. This is the first time I've ever seen Matthew Ferman where he didn't look smug, condescending. He actually is he's an excellent witness. And I hate to say that because I do not like the dude. I don't think the guy's likable at all. I think he's a terrible police officer. I think he should have gotten out of law enforcement the second that he started feeling these feelings, where he starts explaining that all these people that he deals with are bad. Let's continue to allow him to talk so he can share with you what his perspective is on every single person that he stops, regardless of whether or not they have committed a serious crime.
Does that incident, amongst all the other experiences you testified to, stick with you for every traffic stop thereafter?
Yeah, I've had nightmares about that incident. I think about it all the time, and it's on my mind with pretty much every traffic stop.
Now, you brought up, for this stop, but stops in general, somebody refuses to provide information or lies about their name. Remember that?
Yes, sir.
What are some of the reasons, as a law enforcement officer, you've come to know of why somebody would lie about their name?
People never lie about their name for a good reason. The people who lie about their name are the people who have felony warrants. They're wanted for murder. They're in a stolen car. They're parole absconders. They're rapists. They're just bad people. And normal people who aren't hiding anything don't lie about their name. They provide their name, they provide ID. And I would say probably 90% of the traffic stops that I've had go south started with people refusing to provide identification and or lying about their name.
People never lie about their name for a good reason. That's not untrue. That makes sense. It's true that people never lie about who they are for a good reason. That's absolutely true. But what follows is people who lie about their name have felony warrants. They're wanted for murder. They're just bad people. And when I heard them allowing Ferman to just talk, what I thought was the prosecutor was going to let all this information out about Matthew Ferman's worldview and then pounce on him in cross-examination. Let's see if that happens.
Okay.
A lot of times there's also weapons in the vehicle that are not registered to them, or they're not allowed to have a weapon, and that's another reason they hide their identity.
Let's talk about that. Weapons in vehicles. Is that always a concern for a law enforcement officer when they're conducting a traffic stop?
100% of the time.
Okay. Have you ever experienced situations where you've recovered a weapon in the vehicle after a traffic stop?
Many times. Firearms on many occasions, knives and guns shoved under the seat, between the seat and the center console, in the center console, just a split-second grab for the driver. Yeah, okay. Many, hundreds of times at this point.
Why, as a law enforcement officer, is it so important to you to have a vehicle turned off by a driver?
Well, I don't want to get dragged down the road again, so I've made it my policy to have people turn their vehicle off and hand over the keys if I think it's a traffic stop that's going to result in an arrest or vehicle impound or a problematic driver or anything of that nature, just for my safety.
Have you ever been involved in an incident where things start on a traffic stop very, I guess, normal, and then they escalate?
Oh, yeah.
Have you ever had somebody flee on you after you approached their window and asked for their information?
Yes, on many occasions. I've had people literally just throw it into gear and take off. I've almost had my feet run over. I've had people throw it in reverse, ram my patrol car, and then take off the other way. I've had people try and run me over on foot.
Now, as part of also just your experience, but your training, did you provide training when you were a patrol lieutenant at one point, correct?
Correct.
Okay, and you provided training regarding that, is that right?
Yes.
And part of that, was that like just informal training for your patrol officers?
Yeah, a lot of times at the start of shift, I would sit down with my guys and we would discuss various things, some aspect of a law. We'd watch a video of an officer involved in something where an officer got hurt or killed so the guys could learn from it. We'd discuss it. Traffic stops gone wrong, domestic calls gone wrong. I mean, I would try and do something every day with my shift just to keep these guys, keep the stuff at the forefront of their mind. This is a dangerous job. We're the only profession in the United States where we're assigned to take a gun to work because things could escalate like that. No other job has that.
And so as part of that, did you ever review a video titled 18-Year-Old Makes Mistakes with your patrol guys, with your patrol officers?
Yes, we watched that on the shift.
Okay. And that was part of just a training presentation for discussion?
Correct.
Judge, subject to the court's pretrial ruling, I would ask to admit Exhibit D at this time, which is that video. When was the last time you viewed it?
Several weeks ago.
Okay. And that's when we were reviewing it, correct?
Yes, sir, that's correct.
Oh, that's the same video that you showed your patrol officers, correct?
The exact same video.
Okay. And then subject to the court's order, Judge, I took the volume out and then we put a blur at the bottom. Right. When you first saw or presented this video, was this prior to these two incidents that bring us here?
Yes.
Okay. And so this video is something that was in your mind during these incidents?
Correct.
Okay. Okay, I'm going to play that video now. We'll watch it and then I'll ask you some questions about it, okay? While this is playing, Lieutenant Ferman, when you did show this video, what are we looking at right here?
So this is what happens when you don't secure all parties on a traffic stop.
Let me take it. What are we seeing at this point?
So officers conducted a traffic stop.
Okay.
Vehicle's occupied with 3 persons in it.
Okay. Okay, I'm going to pause right here. We see that the driver's been removed out of the car. When you were providing this video, what was happening at this point with the passenger?
So the passenger's not been secured, not been searched, still in the vehicle. Vehicle still has the keys in the ignition. The keys were not secured either by any of the 3 officers at scene.
Do you remember what the interaction was between the officer and that person?
The officer's questioning the passenger at this time.
Okay. Okay. We'll play out the next couple seconds. Okay, so in this situation, this is from the other angle, I take it. Okay. But I need to play it its entirety. What ends up happening after this?
He ends up taking off with the car, and they have to try and track him down before he can endanger anybody else in the public.
Okay. Now, how many officers do you remember being on scene in this?
There's either 3 or 4.
Now, you said earlier this is an example of when. What was the alerting point to this?
A couple things I went over with my officers. Number 1 is this is why you secure the key to a vehicle. And granted, I've had situations where I secured a key and somebody had a spare key and still ended up taking off the car. I actually had that happen twice, but that's pretty rare. So it greatly reduces the risk. And then the other thing was secure and search the passengers. These officers still have no idea if there's weapons in the vehicle. The guy just took off. Now they've got to do another stop. They don't know if there's weapons, if he's armed, what's going on. You have a rear seat passenger, and they don't know what her play is in this. So we had quite a bit to discuss as far as this video goes at the department.
Now, this is a huge missed opportunity for the prosecutor because Ferman is allowed to narrate and speculate here as to what's going on. They want to use it as an example of what it looks like when you don't secure everybody in the car and people get away. And the prosecutor should have objected and said, hey, this calls for him to speculate. We don't know what the nature of the stop was. We don't know what, if anything, has happened that would lead Mr. Furman to come to these conclusions. We do not want to allow this to mislead the jury as to what lawful justifications would be present on a stop that neither of us have any personal or firsthand knowledge of. This should have never been played for the jury, and if it was played for the jury and there was a pretrial motion that allowed it to be played, it should have been strictly monitored by the prosecutor and objected instead of just letting him run with the football all the way to the goal line. This is your criminal defendant who is on trial for having done something criminal in the way that he handles traffic stops, and the prosecutor has allowed him to position himself as essentially a lay person masquerading as an expert on what should be considered a lawful traffic stop and what can happen if you don't do A, B, C, or D. The other thing that is a concern is that he's talking about how these officers should have essentially put everybody in handcuffs and search the vehicle. But he also, in the same breath, says he doesn't know whether they have weapons. So he is telling the jury that he believes that you should be able to get everybody out of the car on every traffic stop anytime you want to. You should be able to take the keys from a person, and that you should be able to search the vehicle, search the passengers, and put everybody in handcuffs and control their movements on every single traffic stop, no matter what. And then he likens somebody just simply fleeing the scene to endangering the public. What was the danger to the public? He left a traffic stop on a traffic violation. That's it. But in Furman's mind, everybody is to be treated like a person who wants to kill him, who needs searched, who is probably the worst of all people, no matter what they are stopped for, no matter the seriousness of the offense. Apparently there was some sort of a motion in limine where the judge allowed this, but you got no objections from the prosecutor here. He just narrates and goes on and on and on, basically positioning himself as an expert, a criminal defendant who's been charged with crimes because of the way he believes that traffic stops should be conducted. And you have no objection from the prosecutor saying, hey, judge, your pretrial ruling did not include his ability to sit here and lecture the jury about what he thinks that is the right way to have a traffic stop. He's on trial for having traffic stops the wrong way. And let the judge at least observe your objection. So I don't understand why this was allowed in. Maybe I'm missing something, and I'm open to that. But I think they made a big mistake here.
I'm going to draw your attention to the incidents that bring us here, okay?
Yes, sir.
I'm first going to talk about the incident that happened with Mr. Williams.
Okay.
And so on July 20th of 2024, where were you?
I was working a traffic enforcement detail in the city of Melvindale, Wayne County, and I was on Greenfield Road.
Okay.
At the time I first observed Mr. Williams' vehicle, I was just finished.
You answered the question.
Okay. That's okay. And so you stated your location.
Yes.
Why were you in that area?
There was utility work going on in the area, which I believe at the time included underground gas lines. And the road was closed. There were two large barricades placed there, orange and white barricades blocking the lanes, and they said on both barricades, road closed. However, people continuously drove around the barricades, and we received many complaints from the utility workers asking us to do something because they felt they were in danger due to the nature of the work and the amount of traffic coming down the now closed road.
So you're there for a specific reason to respond to a community or citizen complaint?
Yes, sir, correct.
They want enforcement. And had you stopped other cars around that?
Yes, over a couple week period, we were doing a pretty heavy enforcement there, not just myself, other officers as well.
Okay. And when you see who you later come to know as Mr. Williams, what did you notice about that vehicle? Why did you stop that vehicle?
So number one, he was on the closed section roadway and had drove around the barricades. As he passed by, the front passenger side window I observed to be tinted, which is in violation of state law. I ran the plate, and LEAN, which is the Law Enforcement Information Network, it's our computer system where we can see vehicle information on the cars, showed that the plate had been canceled for fake insurance and there was no insurance on the vehicle itself.
And so when you made this traffic stop, we saw the video, you approached, is that correct?
Yes.
Okay. And what is your first words to Mr. Williams?
So I can back up just a second. I was a little bit concerned initially prior to walking up to the vehicle because as I cleared my previous traffic stop and got behind Mr. Williams, he turned south on Wall Street and accelerated pretty quick, and it's only a 25-mile-an-hour zone. And in my experience, people often do that if they're trying to get away from me so that I can't hopefully not see their plate and run it because it's a bad plate.
Okay, so let me stop you. So you were on another traffic stop enforcing this barricade issue, correct?
Correct, and I was just clearing from that stop.
When you observed Mr. Williams?
Yes.
Okay. And so when you approach, you get him stopped, and once you approach the vehicle, what's the first thing that you're doing?
Advise him of a couple of the reasons for the stop, including the barricades and the issue with the insurance.
Now, there comes a time where you requested his driver's license, is that right?
Yes.
And why did you request his driver's license?
That's pretty much standard practice on 100% of traffic stops. You want to get the driver identified, ensure they have a valid license, and they don't have any warrants for their arrest.
And was Mr. Williams able to produce a driver's license?
No, he was not.
Okay. Was he able to produce any registration for the vehicle?
No.
Now, at some point, if somebody is driving without their driver's license, is that a crime in Michigan?
That is, Michigan law requires a person operating a motor vehicle on a public roadway have that license in their possession at all times.
Okay. And you didn't immediately ask him to step out of the car, is that right?
Correct.
What other things did you do before you asked him to step out of the car?
I asked him for his name. A lot of times if somebody doesn't have their driver's license with them, we'll get their information, full name first, middle, last, their birthday, and we can go run them in our system and see if we can find the license if they gave us a good name.
At some point, you asked Mr. Williams to step out of the vehicle, correct?
After I realized he was giving me a fake name and could not produce any identification, I became concerned for my safety for the reasons I stated earlier, for things that are typical when people provide fake names and no ID.
Okay. Do you remember if you asked Mr. Williams to turn off the car?
I believe I did.
Okay. And did you ask him to step out of the vehicle?
Yes, multiple times.
What was his reaction to that?
He refused.
Now, it gets heated. You agree with me, correct?
Yes.
You're loud, right?
Yes.
You're direct?
Yes.
At some point, does he comply?
Not until I removed my taser from my holster and I had opened the door and advised him to get out. And when he sees the taser, he does exit the vehicle.
Okay, so why do you remove your taser from the holster while he's refusing to get out of the car?
Under this circumstance, based on everything so far, I am worried about my safety. And typically, the taser is the best form of leverage to get people out of a vehicle. If you go hands-on, a lot of times the officer ends up hurt. People can start throwing punches at you. I've been punched more times than I can count. People tend to be a lot more cooperative when it comes to having a taser pointed at them because they know it's going to be a very unpleasant experience.
Okay. So you're showing the taser, but you're not activating it or clicking it or anything of that nature at that point?
No, sir.
Now, does Mr. Williams exit the vehicle on his own?
Yes.
Okay. And when he gets out, at what point does Officer Rahman arrive?
Officer Rahman, I had called for backup and advised dispatch of the traffic stop, provided license plate and vehicle information. Officer Rahman made my location. He started out the passenger side of the vehicle, and as I was ordering Williams out, he came to the driver's side to assist.
Mr. Williams begins to get out of the vehicle, correct?
Yes.
And what's your next direction to him?
Place his hands on top of the vehicle.
Okay. And does he do that?
Eventually.
Eventually
he places his right arm on the vehicle.
Okay. At what point do you try to handcuff him? What happens next?
Mr. Williams states that the roof is hot, so I then instruct him to put his hands behind his back and interlace his fingers.
Okay.
With the goal of placing handcuffs on him.
Had you pulled your handcuffs at that point?
Yes.
And did Mr. Williams comply with putting his hands behind his back?
No.
After that, what happened?
So I removed the taser cartridge from my taser. I think with prior testimony, the jury understands how the taser works. But from an officer perspective, there's a concern with using the prong method that wasn't discussed earlier, and that is if the prong misses and there's people behind the person you're trying to subdue with the taser, you run a risk of that missing them and hitting somebody else. So there's a female passenger in the front seat and there's two kids. So in the interest of their safety, I didn't want to use the prong feature of the taser because if it missed Mr. Williams or he moved or dodged, there's a risk that it hits somebody else, and I was not willing to take that risk for their safety.
Okay. And so at some point, we see in the video that the taser's clicking, right?
That's correct.
Is the entire time that the taser's clicking, is it making contact with Mr. Williams?
No.
Okay. If the taser's clicking louder, does that mean it's generally free of any obstruction versus it being buried into somebody?
That's correct.
Okay. And when I say buried into somebody, what is the training for a drive stun? How do you do a drive stun?
So in order for a drive stun to work, per taser, per our training, per the instruction manual, You have to take that taser and physically full force drive it into somebody and really make complete full contact and press it in. Otherwise, it has no effect. It just makes a lot of noise.
And so we hear it clicking quite a bit.
Yes.
At some points, does it make contact with Mr. Williams?
Correct.
Okay.
But very little in the grand scheme of things. There's very little actual contact with Mr. Williams. A lot of it's attempting to contact, or it's away from his body and just clicking.
Okay, that's not actually true, but we're not going to find that out, because the thing is, it does have an effect. As I mentioned in the rebuttal episode that I talked about this, when you drive stun somebody, let's just call this to 2 probes on the taser, okay? What happens is when you push the trigger, there's an electrical current that arcs between these 2 positions. And the leads on a taser, those are the wires that connect the darts that shoot out, they're attached to each of these probes, one on this one on this one. One of them comes out completely straight, and one of them comes out at like an 8-degree angle. I can't remember which is which now, but one of them is angled so that the further that you get away from the subject, the further the spread is between where the dart landed and the second dart. One's completely straight, and one of them comes down at an angle. When you use the taser and you shoot the darts at somebody, depending on how far away that person is, that's how big the electrical circuit gets. So if you imagine this right here, it gets expanded by the dart. So if you shoot at somebody like 15 feet away, you might have one lead up in their shoulder, and you might have the other lead down in their leg. And that same little arc that got created between these 2 points now gets created and circulated throughout their whole body based on the distance between those 2 probes. Well, when you drive stun somebody and the darts don't come out, the electrical circuit obviously is in a fixed position. And all you have is you have skin contact, and you are able to put those things against them. Well, yeah, somebody can feel that electricity on one and maybe move their body, or maybe move their body this way. So maybe you only have one connected at one time. In order to actually shock somebody and have electricity circulate, you have to have a closed connection. So he's saying that essentially if you don't have a closed connection, that it has no effect, but that's not true. Those are still hot. You still have electricity coming from each of those. They still burn. They still do all these things. It just doesn't create that closed loop electrical connection that has maximum efficiency. But because your prosecutor doesn't know anything about law enforcement, he doesn't know that this is not true. He doesn't know to object. He doesn't know how to reframe it in his cross-examination to fix what he just allowed Furman to do, to mislead the jury into thinking that when you drive stun somebody and they break connection, it has no effect on them.
Once Mr. Williams goes to the ground, what happens next?
So at that point, I figure it's best to let Rahman and Gall, Lieutenant Rahman and Sergeant Gall, secure him in handcuffs. A lot of times when you're handcuffing people, they twist, they turn, they try and raise their upper bodies. So I take my foot and I set it on his back. Several years ago, we were instructed to make sure we don't kneel on people, nowhere near the head, the neck, nothing like that. And one of the things that was discussed at the department is use your foot to hold down their upper body without kneeling on them, and without going anywhere near the head, neck, upper back. So that's the approach I took, just to keep him flat so that they could secure him in handcuffs. As soon as he was handcuffed, I immediately removed my foot.
Okay. All right. Okay, so after he's handcuffed, no more force is used while he's laying on the ground, correct?
That's correct. Mr. Williams is taken by Lieutenant Rahman and Sergeant Gall to the back of the fire truck and seated.
Well, okay. Prior to that, though, was there another occupant of the vehicle?
Yes, Miss Turner.
Okay, and you approached Miss Turner, is that correct?
Correct.
And you describe yourself as probably verbally aggressive?
Yes.
Why were you verbally aggressive?
She had already attempted to get out of the vehicle without instruction earlier, which is always a red flag for police officers, because we don't know what people are going to do at that point. And if you're dealing with placing one subject under arrest, searching them, everything else, it becomes a lot more dangerous if other people are now out of the vehicle. So I was verbally aggressive. I wanted to let her know that, hey, you can't get out of the car without us giving you that instruction.
We saw the video, so I'm going to fast forward to now the fire truck. You stated who called for EMS after Mr. Williams was tased?
I did. We're required to do so per policy. Anytime a taser is used after the incident, the actual tasering incident, we're required to call for rescue to have the person evaluated. Okay. So I did that.
And did the Dearborn Fire Department respond?
Yes.
And at some point, Mr. Williams is sitting on a fire truck, correct?
Yes.
And you approach him again, is that right?
Correct, because at this time
Hold on, wait. You approached him, correct?
Yes.
Okay. And so why do you re-engage with him? Why do you approach him?
Sergeant Gall found mail inside the vehicle, and I took the mail with the name on it, and I ran it through our computer system, and pulled up who I was sure was Mr. Williams. But a lot of times you want verbal confirmation from the people. Once you discover their identity, you go and confront them with that, and sometimes they'll admit it, sometimes they'll argue, sometimes you find out, oh, that's my twin brother or something else.
So you approach Mr. Williams in the fire truck. I think we can agree your tone and attitude is not the best, correct?
Correct.
Okay.
I was concerned, still coming down from being concerned about my safety earlier and struggling with him. I was at an elevated level, and yes, I regret the language I used, and certainly not appropriate.
But there comes a time where you end up pulling Mr. Williams' hair, is that correct?
Correct.
Tell the jury why did you do that?
So Mr. Williams attempts to get up when I'm speaking with him, and Lieutenant Rahman tries to get him to sit back down, and he doesn't. Through my experience, and at that time 12 years of police work, people in handcuffs can still do bad things. Give an example, my 3rd month on the job, I was on night shift.
You answered the question.
Okay, so there are incidents that have happened to you that are in your head when you're making these decisions.
Absolutely.
Okay. And so we see on the video you yank his hair down, correct?
Correct.
Why do you pull his hair? Why don't you push him? Why don't you knee strike him?
Lieutenant Rahman is pushing him without effect. He's pushing back against Lieutenant Rahman. And one thing they teach you in Police Academy that's always stood out to me, and it's 100% accurate, you control the head, you control the body. And that's the exact phrase they use in Police Academy. Control the head, control the body. And you're taught in Police Academy, you can pull hair, you can use pressure points, you can use whatever method it takes to get a subject under control.
So you didn't tase him at that point, strike him, anything of that nature?
That's correct, no. And I ensured that when I grabbed him by the hair, I kept my hand between his back of his head and the fire truck. So it was cushioned, but at the same time, because the force on the hair and the head, he would have to come down and be seated.
He subsequently transported by the fire department, is that correct?
Yes.
And your interaction with him is then done?
Yes.
Now, Lieutenant Rahman had responded to that scene. What was he doing while you were trying to handcuff Mr. Williams?
He was attempting to hold his right arm at one point. Subsequent to that, he attempted to put him in a bear hug from behind.
Did Officer Rahman have control of Mr. Williams at that point?
No. Matter of fact, when I was trying to gauge that to see if he had control, which it appeared he did not, he then radioed that we have one fighting, which affirmed to me neither one of us think we have control of this guy because he's radioing we have one fighting, and in my visual perspective, we have one fighting.
And why would an officer, or why do you radio, we have one fighting?
Usually that means send more backup.
Okay. So you're asking for more help at that point?
Yes.
And when you first stopped the vehicle, did you ask for help originally?
Yes, I requested another unit.
Okay, so looking at this incident, you're aware of the Melvindale use of force policy, correct?
Yes, sir.
And do you believe that you were in compliance with that policy that day?
Absolutely.
And why is that?
I followed the use of force continuum. I followed our policy, and as soon as he was under control and handcuffed, the force ended until he tried getting up off the ambulance or the fire truck, and then same thing. Once he was reseated, that was the end of the force.
Okay.
So just the minimum amount necessary to secure him.
Does the policy require officers to consider safety measures other than to themselves in that subject, but third parties around?
Yes.
And were you doing that day?
Yes.
Now, the policy also requires you to do a use of force form, correct?
That's correct.
And did you do a use of force form in Mr. Williams' case?
I did not.
Okay. Tell the jury why you did not do a use of force form.
So that was the 20th, and the 21st I went into work. It was my day off, and I was requested by one of the two officers working to come in. Both officers were on forced overtime on day shift. Both had about a year on the job, and one of us, his trial is going on a floor below us right now.
Judge,
Corporal Saeed.
We're going to strike that last comment from the record, okay?
That's why he, okay.
Huh?
I'm asking why he did.
I understand,
Okay.
but that has nothing to do
okay.
with why he did it. Yeah.
Oh, the actual trial, not, okay. No problem. No problem.
So
Okay, I
that's
understand.
going to be stricken from the record. The jury should disregard it, okay?
But
he can talk about what happened.
Yeah, just,
but
don't worry about
it. Future events.
No, fair enough. Why didn't you do the report?
So I was asked by Corporal Saeed to come in Just to work traffic and kind of back them up, he said that him and the other officer working the Uber on forced overtime, they were both exhausted. So I went in, worked traffic detail, so I'd be there to assist them. While I was there, he ended up getting in a foot pursuit with a subject, and while interacting with him, he was executed. The subject pulled out a gun and shot Corporal Saeed to death. I found him about 30 seconds after it happened. Opened up his vest, did CPR. I tried to save him.
Okay, all right. Stop. This is way beyond the
so you
question.
Yeah, I'll get it back.
So last response will be stricken from the record. Disregard.
That is. So did you do use of force? That happened after this incident, correct?
Correct, and I just.
Okay, so hold on. Let me ask.
Didn't get to do the paperwork at that point.
Okay, so you didn't finish the use. You didn't do the use of force form because of that.
Correct.
And that's the same incident that Lieutenant Rahman testified to earlier, while he didn't follow up with reports. Correct.
Correct.
Right. And see, the prosecutor finally objected, but he objected long after he's been saying way too much. Look, the question is, why did you not fill out a use of force report? The answer is because we had an officer-involved shooting where an officer got killed, and I just forgot to do the report. That's it. That's all this prosecutor should have let him get by with. Instead, he goes on this long thing. He gets to be humanized. He shows emotion. He builds sympathy and empathy with the jury because the prosecutor did not object in a timely fashion. And you can strike it all you want, but it's in the mind of the jury now, and now they know. Now they know that right directly below them, there's a trial for the person who murdered his partner while he was there backing him up. And that didn't have to happen. They weren't supposed to know that. The difference is, and this is where you know the quality of the lawyer, okay? Dennis Whitey did a really good job of allowing Furman to push the boundaries, knowing that this prosecutor is not going to do anything about it. And every single time he pushes a little bit more and a little bit more, and the prosecutor does nothing. Whereas the prosecutor wasn't there standing guard to make sure that it didn't go too far. And Dennis Whitey won the opportunity to teach a little bit of stuff on that traffic stop in his pretrial ruling. And because the prosecutor was not there standing guard to make sure that more than he wanted to come in got to come in, then we got to see Ferman educating and teaching as if he's a training officer about traffic stops in the last slide. So this is real failure on the part of the prosecutor to not gatekeep the evidence, and that's the reason he's going to ultimately lose some of these charges at the end.
Okay, I'm going to change gears here. We're going to turn to Mrs. Cook's incident. On April 13th, 2024, do you remember where you were?
Yes, it was in the area of Outer Drive and Wood Street near ABT school.
And were you on duty?
Yes.
Or did you come in contact with a Mrs. Cook?
I did. I observed her vehicle.
Can you answer the question?
Yeah. Did you come in contact? Yes. And
yes.
Why was your attention drawn to her?
Her vehicle was parked in a school parking lot during not school hours.
Was there any reason? What would you take in reference to that suspicion?
That particular school, we've had a lot of alarm calls at off hours. It's a school for troubled kids, so we get fights up there, we get alarm calls, we get other issues. So we try and keep a fairly close eye on it, especially at night and on the weekends.
Does there come a time where you approach that vehicle?
Yes, I observed it in the parking lot. I ran the license plate, found some violations, and then initiated a stop.
Okay, when you say you found some violations, what were those?
The license plate was expired. There was no insurance on the vehicle.
And is that a reasonable basis to stop a car in Michigan?
Absolutely.
Okay. Now, I know there's an issue that she was in a parking lot of a school, and I believe that was addressed on the video, but do you have jurisdiction to investigate somebody in that parking lot?
We do. That's what's...
Okay, you've answered the question. Next question.
Was that a public access school lot?
Yes, it was a public access parking lot.
You run the vehicle, you determine there's some issues with registration, potential insurance. Does there come a time where you approach the vehicle?
Yes.
Okay. And what happens?
I make contact with Ms. Cook. I advise her of the reasons for the stop. I request identification, vehicle paperwork, and ask her to turn the vehicle off.
Okay. And were there others in the car?
Yes, on the older side of teenage front passenger.
Okay.
And there was another would appear to be teenager or thereabouts on the younger side in the back seat.
You asked Ms. Cook for her information, I believe you stated, correct?
Yes, sir.
Did she provide that?
No.
I believe you also said you asked her to turn off her car, is that right?
Yes, sir.
And what was the reason for that?
Based on my training and experience, if there's an issue with the plate and there's a good chance the vehicle is going to be towed or there may be an arrest made or something like that, I always secure the key. It's practice on any traffic stop like that.
Okay.
just for my safety.
And so, does Miss Cook turn off the car?
No.
Did you give her multiple warnings to do that, or was it just one time?
No, I asked her several times to turn the vehicle off and to provide the key.
Okay. Does there come a time when you tell her to step out of the vehicle?
Yes.
Okay. And does she do that? Do you get on the radio and ask for more units or help?
Yes.
And when you do that, well, let me back up. So you're asking Miss Cook to step out of the car, correct?
Yes.
Why are you asking her to step out of the car?
Same thing. When I have somebody who's refusing to provide ID, refusing to provide any paperwork, just raises the red flags about as high as they'll go. So at that point, I'm concerned for my safety. I don't know what's in the vehicle. I don't know if there's weapons. The fact that she's a female doesn't change anything. I've been attacked by multiple females over the years. So I want to get her extricated from that vehicle where I can talk to her, where she's out of reach from any potential weapons, where I can see if there's anything on her that can hurt me, get her patted down and secured, and then find out who she is, since at this point she's refused to provide identification.
Okay. And so when she refuses to step out of the vehicle, what do you do in response?
I asked her a number of times to step out. I then drew my taser and advised that if she did not, she would be tasered.
Okay. Did you try to remove her from the vehicle?
Yes, I initially tried to physically pull her from the vehicle, but she grabbed the steering wheel and I could not get her out.
Okay. So fair enough to say you tried to pull her out before pulling out the taser?
Yes, sir.
Okay.
That's correct.
And so you're telling her to get out of the car, you pull the taser, you warn her she's going to be tased. Do you remember how many times?
I don't remember the exact number. I think it was 3.
Okay.
But it was multiple times.
Okay. And does she comply and get out of the vehicle?
No.
Okay.
There's
And
no
what do you do
compliance
next?
at all.
Okay. What do you do next?
I aim for the meaty part of her leg, the outside of her leg, and which is in accordance with our training. You want to go for the larger muscle groups and keep it away from the head, neck, face, genitals. So I went for her leg, which is the safest area that I could use the taser on, and I deployed my taser.
When you did that, was that effective at all to subdue her?
After the first taser round, no. She was still in the vehicle and still not coming out.
Okay.
And I'm ordering her very loudly, very clearly to exit the vehicle.
Was she moving her arms and flailing about, or was she completely still?
I believe she was moving a bit,
Okay.
yes.
Eventually, I believe a backup officer arrives, is that right?
Yes, 2.
Okay. At what point does Ms. Cook come out of the vehicle?
She came out after I deployed the second charge with the taser.
Okay.
Then she decided to comply and exited the vehicle. I ordered her to the ground.
Okay, so let me stop you there. So she comes out of the vehicle herself, correct?
Correct.
And then you order her to the ground.
Correct.
Okay. And then what happens?
I wait for the backup officers to arrive so that I'm not trying to handcuff her by myself.
Yeah.
And I let the 2 officers who arrived on scene secure her in handcuffs.
Okay, fair enough. Did you tase her at all after she was out of the vehicle?
No, there was no need. She was on the ground, and at that point, she was compliant.
Okay. So once she complied, you used no more force?
Correct, 0.
And again, you are aware of Melvindale use of force policy, correct?
Yes, sir.
And how would you, pulling on the steering wheel from being, refusing to come out of the car, what level of force is that?
That's to the point where I can utilize my taser.
Correct. Okay. I have the exhibit. Do you want to see the chart? I'm going to ask you to.
Sure, yes, sir.
We have Defense Exhibit A up on the screen that was previously admitted. That's the subject control continuum. Is that correct?
Yes, sir, it is.
Okay. And that's, I believe you testified earlier, this is the standard incorporated in the Melvindale Police Policy?
Yes, sir.
Okay. And we have subject's action of inactive resistance, passive resistance, active aggression, and deadly force. Where was Miss Cook as she's pulling on the steering wheel and refusing to get out of the car?
Active resistance.
Okay. And so active resistance, what's the officer's response?
Intermediate controls. You can also use physical and compliance controls.
Okay. And physical compliance controls under policy includes the taser, correct?
Yes.
Any particular reason when she wouldn't get out of the car you didn't strike her?
The taser, in my 12 years of experience, results in the least amount of injury to a person. I mean, I've been tasered as part of training, and it's not pleasant, but when it's over, that's it. There's no injuries, there's no
long-lasting effects.
Correct. Okay. Whereas if you punch somebody, they're probably be sore for a week, and it's like you don't really want to do that if you can. I mean, I don't want to use force under any circumstance if I don't have to.
Well, hold on, let me back you up because Judge Orendison. So the question, though, before you is that you did not strike her, cause pressure points, anything of that nature, correct?
Correct.
Now, I noticed at one point in the video with Miss Cook, one of her kids kind of come out of the back seat. Do you remember that?
She had one front passenger
Do you
and one
remember
rear
it?
passenger.
That's the first question. Do you remember it?
The kid coming out of the back seat?
Yes.
Not until I instructed her to.
Okay. Oh, so you instructed her to come out of the back seat, correct?
I instructed the passengers to exit the vehicle.
Okay. And then I believe in the video you say get away from the car?
Yes.
Any particular reason you had them do that?
Yes. A concern for an officer, kind of like we went over earlier with that video, is that if the key's not secured and there's passengers in the vehicle, especially a teenager, they can easily take off with that vehicle, run somebody over, run somebody down, take off, endanger somebody else while fleeing. So I wanted everybody out of that vehicle, away from the key, away from the driver's seat, away from where they could, if there's any weapons in the vehicle they could grab, just away.
Okay. Did you, in this case, do a use of force form?
Yes, sir, I did, immediately after the stop.
And that was submitted through channels, is that correct?
Yes, sir.
And that went up to, I believe it's Chief Canale, is that right?
Yes, sir. He was our chief of police at the time.
Okay. And was the department's position the force was reasonable under the continuum?
Yes. The chief actually called the text.
Okay. Good enough. I'm going to ask you about both of them. You used pretty rough language. Do you remember that?
Yes, sir.
And one, you call Mr. Williams a retard. You're going to jail, MFer, things of that nature, correct?
Yes, I did.
Same thing with Miss Cook. After the struggle, you were pretty worked up, loud, correct?
Yes.
And looking at those videos, do you think that was appropriate?
No. Unfortunately, in the heat of the moment, I was quite loud, and you go into that fight or flight mode, and it kind of elevates the temperature and elevates the language, and then you come down from it.
All the actions you took in both of these cases, you agree it was completely in conformance in the directives of the Melvindale Police Department?
Yes, 100%.
I just don't have anything else.
So that was the direct examination. Now comes Matthew Makepeace's opportunity to cross-examine Matthew Ferman. Now, I want to tell you guys, prosecutors, and I mean like real prosecutors, salivate at the opportunity to cross-examine a criminal defendant that they believe they can prove beyond a reasonable doubt is guilty. The reason is because very, very, very few testify in their own defense. And I would have recommended to Matthew Ferman that he not testify in his own defense. However, they made the right call, because if he doesn't testify in his own defense, all the jury gets to see is this obnoxious, aggressive person who makes a pattern of escalation on every single traffic stop. So the only way that they could introduce a different type of Matthew Ferman to the jury was for him to testify. So it didn't surprise me that he did testify. But I want you to understand something. The test of your mettle as a lawyer and a prosecutor is whether or not you get bodied by a criminal defendant who has to be subject to your cross-examination. And so, Matthew Makepeace should be ready. He should be foaming at the mouth for an opportunity to cross-examine this guy. And the first thing that I would do is I would revisit the last case they talked about, because that's what's fresh in your mind. Those are the things that you just heard this information. So your best chance at retort as a prosecutor or just as a lawyer on cross-examination is the information that you just heard, because you have like recency bias. You know what was said, right? So he should have immediately gone at the incident about Alicia Cook. Let's see if he does it. And then what I'm going to do with the cross-examination portion is tell you what I would have asked in the situation as a prosecutor and contrast that with what he actually asks. And I will just tell you, just as a clue, before I ever saw this, I already thought that he fumbled the ball, and here's why. This video is an hour and 39 minutes long if you watch it in its entirety. I've clipped only the things that are relevant for our discussion, but it's an hour and 39 minutes long. The direct examination ended at right around the 1 hour mark. That means that Matthew Makepeace spent 2/3 of the time crossing him that he allowed him to testify on direct. And that tells me that he didn't do a thorough enough cross-examination. He should have been there for at least as long as he testified on direct, and probably 50% longer. But we're going to give him the benefit of the doubt and watch and see what happens.
I'm going to pick up right where Mr. Whitey left off. You said that earlier and just now that both for Williams and Cook, you believe you were within Melvindale policy. Is that correct?
Yes, sir.
So let's talk about the Williams case. If you were encountered with that exact situation again, you would have done today the exact same thing, correct? Stick to the use of force.
I would use my taser if necessary.
Okay. I'm saying exact same thing. You would have no problem doing that again, right?
I'd probably try and find different tactics.
Okay. And when you were on scene, you used those words that we talked about, excluding the use of force. You called Mr. Williams a retard and motherfucker and all those things, right?
Yes.
Okay.
I did.
You were aware that within the use of force policy, it says every person is entitled to respect and dignity, right?
Correct.
Okay. That was outside of that policy then.
It's also been discussed in the department when discussing that particular policy that
it's a yes or no question, sir. That's outside of the policy. Calling someone a retard and a motherfucker is not treating them with respect, right?
Correct.
Oh, you just said you would try and find different tactics with respect to Mr. Williams, right?
Correct.
Why do you say that now?
Well, because we're here.
Okay. Now, on the scene, you didn't have any problem with what you did, right?
No, I went home alive.
Okay. You were talking after everything was all said and done and Mr. Williams was taken away. You had a conversation with Lieutenant Rahman, right?
Yes.
And several other officers.
Yes.
And in fact, you said this to Lieutenant Rahman.
Man, I got zapped a couple times too. Sure, brother. Yeah. Should have fucking tased him.
What'd you say there? You should have just tased him?
Correct, meaning with the prongs, because he would have been immediately incapacitated.
So even on the scene, you thought you should have done something differently than what you did. Is that fair?
In hindsight, yeah, I thought it may have been an option where that may have worked out better.
Now, let's talk a little bit more basic. You were working as a Melvindale police officer on both of these days, April 13th, 2024, right?
Correct.
And July 20th, 2024.
Correct.
And you were being paid to work there.
Yes.
And you were out on the street working traffic enforcement details, doing your roles.
Yes.
Okay.
Enormous missed opportunity here on a couple fronts. One of the first things that you notice, the difference between Dennis Whitey and Matthew Makepeace is that Dennis Whitey walks up with no notes. He walks up with a personality. He knows all the facts. He's got it all memorized. He's just putting on a show. He's telling a story. He's weaving facts and circumstances. He is performing for the jury. Matthew Makepeace walks up with a binder this thick, opens it up on the panel, and takes 30 awkward seconds to try to get ready, and then starts asking questions. Here's the thing that you need to understand. He does not do a good job of developing anything beyond the initial question. And then what that tells me about him was that he drafted all of these questions and did not have forks in the road for what Ferman might say. And Ferman gave him nuggets of gold. Nuggets of gold. First of all, Ferman says, when he said, this is a great question. So if faced with the situation, again, with Jakar Williams, you would do everything that you did, right? He said, I would use my taser if necessary. Beautiful opportunity. Great question. Did not have a plan for what he might say if Ferman said, I would use my taser if necessary. Well, let me ask you this. What makes you question whether or not your taser use was necessary today versus whether or not your taser use was necessary then? What circumstances were absent, looking back with the benefit of hindsight, for it to make it necessary for you to use your taser? And let him talk. He didn't do that. Second opportunity he missed. After he failed to ask the question about, well, what would make his conduct necessary for a tasing, he just moves on to the next question that he already memorized in order to do this. He's nervous. He's visibly nervous. And that's, you can't blame people for that. This is a big, high-profile case. But notice the difference between Ferman's demeanor and his demeanor. He looks like a rookie who doesn't know what he's doing, and Ferman looks like a seasoned veteran who is cool, calm, and collected. And importantly, that's a demeanor and disposition the jurors have never seen from Matthew Ferman. He's not being pushed around. He's not getting worked up. He's completely chilled and answering this dude's questions. But the next question was, I would probably try to find different tactics. So he missed it when he said, if necessary. And then he also missed it when he said, I would probably try to find different tactics. Oh, awesome. Please share with the jury what, with the benefit of hindsight, you think you could have done differently in this situation, and let him talk. So what does Makepeace do with that information instead of asking, well, what would you do differently? he starts to focus on all the things that everybody universally knows is a shitty thing to do to Jakar Williams, which is to call him a names, call him an MFer, tell him he's going to jail, all that stuff. Everybody knows that. This is not something that you need to focus on. This does not prove a corrupt intent. It proves that Matthew Ferman doesn't like people and he's not a very nice guy. That is not a crime. And you focus your theory of the case on a stipulated fact that Dennis Whitey was smart enough to stipulate from the beginning. My client is an unlikable asshole. That does not make him a criminal. So your job was to take that information, dodge it, and be like, okay, these things do make him a criminal. Didn't do it. You moved on and started talking about policy. And then you ask him a follow-up question. He asks him, why do you say you would do things differently now? Well, because we're here. Perfect opportunity. Why didn't Makepeace say? So are you saying that you would do things differently because you see the situation differently with the benefit of hindsight? Are you saying that you have regrets? Are you saying that you wish you had done things differently because Jakar Williams didn't need to be or didn't deserve to be treated like he was an animal? Or are you saying that because you've experienced consequences? But instead, what's he say? So you were on scene, you were okay with what happened, right? Again, not a bad question, also not the very best way that he could have responded to Furman's answer. Yep, I went home alive. And what's he do? He moves on to the next question that he already had written and drafted and pays no attention to the opportunity that exists to take advantage of that really silly answer. The answer was, yes, I went home alive. So let me make sure I understand this. You stopped Jakar Williams for a traffic violation. The greatest crime that he's accused of in this entire thing is giving you a false name, which admittedly is an arrestable offense, or a traffic violation. Are you saying to the jury that no matter what a person does, no matter how minimal, no matter how severe, that the only standard that you adhere to is that you think that it's okay to do whatever you feel is appropriate, so long as the end result is that you get to go home at the end of the night? His answer to that would have been yes. And then you've trapped him. He is the exact person that everybody knows he is because you followed up on the question. You didn't just take it and move on to this like robotic idea that you had in your cross-examination. You must build in a fork in your mind for what you're going to say. There's only a closed universe of things that people are going to say in response to your questions. So if you're a pro se person and you're defending yourself, or you've got a deposition coming up, or you have an opportunity to put police officers in a seat and ask them tough questions, think about this. Think about the closed universe of the things that they might say in response to your questions, and have some response in mind for if they say one of those like 4 or 5 options. Makepeace didn't do that. He just moved on to the next thing that he had written down in his notebook. And he took an obnoxious amount of time in getting to the next part. And it showed the jury that he was not prepared to cross-examine Matthew Furman. I hate to kill the suspense, but Matthew Furman pretty much handles him through the bulk of this cross-examination.
And now we talked a lot about tasers as well. You understand that a taser can cause serious injury. Not always, but it can, right?
Anything has the potential to cause a serious injury.
Okay. You said on direct, you talked about Mr. Williams and when you grabbed his hair and pulled it into the fire truck, right?
Correct.
And you did that. You grabbed his hair. You said that you used your hands to cushion the blow against the fire truck.
Correct.
Okay. You did, in fact, write a report in this matter, correct?
Yes.
When did you write that report, by the way?
I don't know the exact date.
Okay.
There was a delay due to the murder of Corporal Said.
Understood. In that report, well, let me ask you this. When you write a police report, you include all of the details, correct?
You try to, yes.
Okay. Particularly when force is used, you would include any time that you use that force.
You would try to, yes.
Okay. With respect to when you were pulling on Mr. Williams' hair, you wrote, I feared Williams would attack myself, Lieutenant Rahman, or fire personnel. I have seen handcuffed persons attack police and bystanders on countless occasions during my career, and I am cognizant of that. Williams began screaming, you're pulling my hair and pulling against my grip. I let go of Williams' hair and he stood up. You never mentioned anything about putting his head into a fire truck in that report, correct?
I don't recall.
Okay. Would you like to see that portion of the report?
Yes.
Okay. May I approach, Judge?
States here, I exited my patrol car and walked to where Williams was seated on the rear bumper of the, I call it ambulance, not fire truck, but the rear bumper. And then I addressed his issue about the warrants and his ID.
Okay. Nothing about the use of force with the hair actually making contact with the fire truck though?
Well, I put in there that, yeah, his hair was pulled. I let go of Williams' hair and he stood up again. I observed Lieutenant Rahman pushing Williams back to a seated position as Williams pushed against him being Lieutenant Rahman, screaming about free speech.
And that's the portion that refers to that incident at the back of the ambulance, right?
Correct.
Oh, you, in that portion that you just read, you mentioned that Williams's head made contact with the back of the fire engine.
No, I mentioned that it was had taken him by the hair and let go of his hair.
Okay, huge missed opportunity, again, with this questioning by the fire truck. What was the legitimate law enforcement objective that you were trying to accomplish by having him sit down? And what was it about that that necessitated you grabbing his hair? Makepeace goes on this big issue, and he occupies 2 minutes of time to quibble about whether or not Matthew Furman wrote in his report that Jakar Williams' head hit the back of the truck. Their entire theory throughout the whole trial has been, no, his hand was between Williams's head and the fire truck. So why is Makepeace highlighting this? He's not doing anything to demonstrate the fact that the use of force was unnecessary. He's not highlighting the fact that there is nothing about the guy sitting on his butt with his hands behind his back with officers on both sides of him that should have made him a threat. He's not demonstrating the fact that the only thing Ferman wanted out of this encounter was control and to be able to boss him around and tell him what to do, and he was willing to do whatever it took in order to achieve that. Makepeace just glides over it, hoping that he'll catch him in a lie or some inconsistency, but the issue is that Matthew Ferman is better at this than he is. He's better at arguing with people because as a prosecutor, like I mentioned before, you really don't ever get a chance to cross-examine the defendant. So he is not prepared for this. He's not prepared at all. And Matthew Ferman has a good lawyer. And that lawyer has come at him from every different direction during the pre-trial preparation for this case, doing his best to say everything he can possibly think of that might come out of this prosecutor's mouth. And the prosecutor has not even considered what he's going to say in response to Ferman, or if he did not do a very good job of creating pathways to make the points that he's trying to make, and he doesn't seem to be making the points that will prove the elements of his case.
Well, let me ask you this. You've heard of the term, and I'm not a police officer, but friendly fire. You've heard of that, right?
Yes.
And you are trained, particularly with firearms or any potential projectile, that you're not going to point it at someone, even if it's unloaded, unless you intend to use it, right?
Yes.
And you testified on direct with Mr. Whitey that the reason you went to the drive stun with Mr. Williams is because you were concerned for the safety of the other passengers in the car, right?
Correct.
Okay. You did use the prongs with other passengers in the car with Miss Cook, though?
Correct.
Okay. You were also, as you said on direct, concerned about the other passengers with Mr. Williams. You would have also been concerned about your fellow officer's safety, correct?
Correct.
You do admit that you tased Lieutenant Rahman while in attempting to tase or drive stun Mr. Williams, right?
Yes.
Oh. One of the biggest, as you said, you're familiar with the policy, one of the biggest things in that policy is objective reasonableness, right?
Correct.
You are taught and you know that you consider, when using force, various different factors, right?
Correct.
One of the biggest ones is the crime that was committed or is attempted to be committed.
Correct.
The crimes that you pulled Mr. Williams over for were what?
Well, civil infractions and misdemeanors.
Okay.
However, with him refusing to provide ID, I don't know what else we have.
I asked you, what crimes did you pull him over for? Civil infractions and misdemeanors, right?
Correct.
Okay. Traffic offenses.
Correct.
All right. That is relatively a low-level crime. Fair? Misdemeanors.
Correct.
And then you approach the car, correct?
Correct.
And you assume that he's giving you a fake name at first.
I'm
you confirmed it, fair. You assumed at first, though.
With about 99% certainty, based on my experience, yes.
And you testified on direct that people who give fake names are rapists and murderers.
I said they can be. They're often hiding things, is what I said.
Now,
there's a reason they provide a fake name.
Stop. You've answered the question. Next question.
It is possible for someone to give a fake name because they're scared, right?
It's possible, yes.
Okay, stupid question. First of all, he shouldn't have focused on the rapists and murderers because those are people that everybody's going to have a problem with. You don't focus on rapists and murderers. Everybody wants rapists and murderers to go to jail. What you focus on is the fact that he categorized as anybody who might not give him their name or comply with his order as bad people. That means that anybody who has an outstanding open container warrant, and it would be very inconvenient for them to go to jail today, might give somebody a false name. Does that make them a bad person? No, of course it doesn't. And then he says it's possible for somebody to give a false name because they're scared, right? And Ferman goes, yeah, it's possible. Guess what? That also applies to rapists and murderers who don't want to go to jail. So you did not prove any point, and you missed an opportunity to prove one that would actually matter to the jury. Matthew Ferman thinks that everybody that he stops is a bad person. That's the point you should be driving home, not that Matthew Ferman doesn't like rapists and murderers, so that probably doesn't align with your worldview. Who likes rapists and murderers? It doesn't make sense.
When you turned on your lights, or did you turn on your lights and sirens to pull Mr. Williams over?
Yes, it was in a fully marked patrol car.
When you turned on your lights and sirens, he stopped immediately, right?
No, he rounded Wall Street, he accelerated and then slowed down.
Okay, but he did stop. He didn't flee from you.
Correct.
And when you opened Mr. Williams' door to get him out of the car, is that right?
Yes.
When you do that, Lieutenant Rahman is standing right next to you, or he eventually comes next to you, correct?
Correct.
That's when Mr. Williams got out of the car.
Correct.
When Lieutenant Rahman asked him out of the car.
No, when I had my taser aimed at him.
Placing on the screen what's been admitted as Exhibit 3 and playing from 1 minute and 20 seconds.
Is this coming out? Yes. I see you shoot my taser. Get out of the car. Stay right there. Get in there.
You heard Rahman ask Williams, can you step on out? And he said yes, right?
Mm-hmm.
Okay.
Yes, sir. Yes, sir.
And then you pulled your taser after Mr. Williams said he would get out of the car, right?
Looks to me like I was in the process of retrieving my taser as Lieutenant Rahman stated that, but it was in my mind the taser was coming out and I gave him the directive involving the taser.
Now, that got him out of the car, and then you testified on direct that he put his right hand on the hood, correct?
On the roof, yes.
On the roof. Sorry. Hood, roof, yes. What did he do with his left hand?
He did not put it on the roof, from my recollection.
Showing that same exhibit, Exhibit 3, at 137. Do you see both of Mr. Williams' hands there?
Yes, sir, I do.
Where are they?
I believe that's his hand on the left and then the right. Okay, so it is up there.
Now, it was shortly after that moment that we saw there that you deployed the drive stun into Mr. Williams' back, right?
Correct.
Are you familiar with that taser manual that was shown earlier and admitted earlier?
Yes.
In that manual, it says that people are likely to react instinctively to the drive stunning, correct?
I believe so, but I'd have to see the actual language.
We're approaching with what's been admitted as Defense Exhibit B. I'm showing you page 20. It's cut off, but I believe it's 21. Yep, 21. And it says that the subject is likely to recoil and try to get away from the energy weapon, that being the taser, correct?
It does state that.
And that's what Mr. Williams did when you initially drive stunned him, correct?
I think it was a combination of that and trying to prevent himself from being arrested.
You would agree with me that in that policy, other police officers have a duty to intervene when they see excessive force being used, right?
Yes.
Lieutenant Rahman did try and stop you. He was yelling stop, right?
I had no idea that was at me, and I had no way to know that was at me.
Lieutenant Rahman also, by the fire truck, positioned his body in between you and Mr. Williams and said, I got this, Ferman, correct?
Correct.
Let's talk about the moment that you initiated the first drive stun on Williams. He wasn't moving when you did that, right?
He was not following instructions to place his hands behind his back.
Let's go back to that then, because you had your eyes open, obviously, when you were interacting with him, right?
Yes.
You saw where Lieutenant Rahman was.
Yes.
You saw that at that moment, Ms. Turner had gotten out of the vehicle and gotten back in the vehicle, at your direction, right?
Correct. Well, my direction was to get back in, yes, not
to get back in, yes. And Lieutenant Rahman, I think, told him too, fair?
I believe so.
Okay. The only person out of the vehicle was Mr. Williams.
Correct.
There was 2 officers within arm's reach, you and Lieutenant Rahman.
Correct.
And you saw, when you're telling Mr. Williams to put his hands behind his back, where Lieutenant Rahman's arms were and hands were.
Right? I believe so.
They were on Mr. Williams' shoulder and elbow.
Of his right arm, correct.
Of his right arm, fair enough. You're yet, even though Lieutenant Rahman has him on his right arm, on top of the car, telling him to calm down, you're yelling at him to put his hands behind his back. Is that fair?
Correct.
And as you're saying it the second time, during you say it, you don't finish it. You just tase him as you're saying it, correct?
Correct.
You did not give him any chance to comply with that second command.
Shouldn't have been need for a second command. He should have complied after the first. And with a drive stun, you typically want to use that, if possible, as a surprise, so that people aren't able to prepare to attack or defend themselves from that.
Okay. His back was to you, fair?
Correct.
So he would have no idea when you're going to do it.
Not necessarily. Okay. He already knew the taser was out, because I drew the taser when he was still seated in the vehicle facing us.
And when you tased him, it wasn't in reaction to any movement from Mr. Williams, fair?
It was in reaction to failure to comply.
Okay.
Right there. He gave Makepeace an absolute gold nugget. He shouldn't have required a second order. He should have immediately complied. What do you hear Makepeace do? Turn the page in his notebook and move on to the next question. So let me make sure I understand this, Mr. Furman. You're saying that you don't think there's any room for a human being to even have time to interpret your first command or ask you a question about whether or not they think it's reasonable that you asked them to do a certain thing. Your position and what you want to explain to the jury here today is that whenever you say jump, the only question should be how high while they're in the process of jumping. That's your testimony. That's your position, that people have no right to question anything that you say as long as you are wearing a badge and a uniform. If I'm wrong about your testimony, explain it to me like I'm 5, because I'm having a hard time understanding. But what do we see? Flip the page, move on to the next question.
In addition to the manual that comes with the taser itself, there's also a taser policy that Melvindale has.
Yes.
Where in the taser policy that Melvindale has does it say you should drive stun by surprise?
I don't know that that's in there, but through 12 years of police work, I find it's better if it works that way.
Oh, fair enough to say it's not in there.
I don't believe so. Oh. But you learn how to do things tactically on the street that may not be in a manual, that work better and keep you safer.
Now, after that initial taser, sir, Rahman pushes Williams to the door jam, fair?
Yes.
Okay. Look at what just happened. First of all, he's focused on the wrong thing. It doesn't matter whether you drive stun him by surprise. It doesn't matter whether you drive stun him and say, hey, I'm going to drive stun you. It doesn't matter. You've already given the guy a warning that you're going to taser him. Okay. You're focused on the wrong thing. But even focused on the wrong thing, he gives you a glimpse into his worldview that you can exploit. And you're so focused on your robotic cross-examination that you stayed up all night drafting because you're just going to slam dunk this guy. What did he say? Well, no, but you learn, when you're out on the street that you have to do different tactics that aren't exactly in the manual. Oh, so I understand. I get it now. All this time, I was trying to figure out how I could reconcile Matthew Furman's conduct with what's in the policy manual. But what you're telling me is that you play by your own set of rules. So can you tell me what the Matthew Furman rule is about when a person does this, since obviously policy is not your roadmap? This whole time, I thought I was trying to figure out what policy you were going to lean on to try to justify your actions, but you actually don't need a manual. You just do whatever you think is appropriate. The law is not a manual. The policy is not a manual. It's whatever Matthew thinks in the moment. Do I have that right? You don't need an answer. It doesn't matter what he says. You have the ability as a lawyer to score your points with the way you ask the question. More than likely, that question's going to get objected to as argumentative, and he's not even going to be allowed to answer. It doesn't matter. You don't need the answer. You have taken the data that he just gave you, and you have turned it into a reasonable interpretation for the jury to have that was created in your mind, and you have handed it to them for them to think about. But he's not living in the moment and taking advantage of the mistakes that Furman is making. All he's doing is moving on to the next thing that he had in his notebook.
And at that point, again, Ms. Turner and the 2 children, the young children, are in the car.
Yes.
You don't see them do anything in response to that. They're yelling maybe, but they don't get out of the vehicle, right?
Well, Ms. Turner had already attempted to get out of the vehicle and she was ordered to get back in.
Not my question. She did not get out of the vehicle in response to the tasing initiation. She stayed in the vehicle, right?
I believe.
Okay.
Yes.
Well, you eventually went around to her passenger door, and she was still there.
Yes.
Okay. Rahman has Williams up against the door jam. You reach under, through Rahman's legs, and tase him in the caps. Is that fair?
Correct.
You then do that a few times, walk around to the front of the vehicle, and tase him in the chest. Fair?
So when I attempted the calf, it didn't work, and he lifted his leg up and tried to stomp on the taser, as shown in the video. So I removed myself and attempted from a different angle.
And all the while you have your handcuffs in your hand too, right?
Correct.
And you didn't at any point with your handcuffs in your hand try to cuff one of his wrists, did you?
Well, that was the goal, but I was unable to with the moving around. He also attempted to grab the taser, and as you can see in the video, he does actually grab the taser.
Okay. At what point in the video, what second is that, or what minute, second?
I don't know the exact minute or second.
Oh. Fair enough, though, as Mr. Whitey said, the video is the video, right?
Yes.
And we have all seen it?
Yes.
Okay. Placing on the screen still shots from Exhibit 3, Rahman's body cam. Are you able to see that, sir?
Yes.
I'm just going to click through these somewhat fast and just watch them as we go, okay? And stopped at this one, which is, well, it's part of the exhibit, Exhibit 3. Your hand is on his wrist, Mr. Williams' wrist, right?
Yes.
And continuing on from there. You would agree with me that you're moving his wrist out of the way to continue tasing him, correct?
To get him to comply, correct.
Okay. And at this point, you have physical control of one of his arms. Is that fair?
So I don't think that grip looks very good, but I'm attempting to.
Okay. And at this moment, this is from Rahman's body cam, he's in that door jam. Fair?
Correct. Looks like it to me.
Okay. Mr. Williams at this point is not going anywhere, right?
I wouldn't say that with certainty.
2-on-1.
I've had 3 or 4-on-1 and people escape, injure all the officers. I can't speculate on that.
He's not in the car, correct?
He's right in the opening of the driver's door.
With Rahman behind him, fair?
Correct.
Okay. When going back, I'll take this off the screen.
You have control of his wrist, and you are continuing to use a taser on him, right? And he says, well, it doesn't look like it's a very good grip. Well, wait a minute. What would be a better grip? It looks to me like I can see all 4 of your fingers. We know that there are some pressure points and pressure point control techniques that are taught for controlling this wrist, and you had a good enough grip on it that you were able to successfully move it out of the way. So either one of two things has to be true. You would agree with me. Either he was not resisting to the extent that he was pulling that wrist away, or you had a good enough grip that you were able to redirect it in order to continue tasing him. Which one is true? Guys, I don't even know this case, and I can come up with this on the fly. Why did he not know this? Why was he not prepared? Why did he not know the facts any better than this? Why did he feel like he needed to just go through his little checklist and give Matthew Ferman the opportunity to become an expert in the eyes of the jury in police operations and use of force?
Going back to when Mr. Williams had both hands on top of the car, you had your taser in handcuffs, right?
Yes.
Okay. You said initially that you took your taser out to have leverage to get him out of the car, correct?
Correct.
And he got out of the car.
He did.
You didn't have to pull him out.
No, that's why we like to use the taser. Usually it gets people to come out.
And then you keep your taser out and grab your handcuffs, right?
First, I removed the prong cartridge from the taser, and I did keep it out.
And that's what goes to drive stop.
Correct.
Okay. So you have
to physically take that off the end.
And I think we see that you do that in the video.
Yes.
Or one of the videos anyways. But nonetheless, both of his hands are on top of the car. You have handcuffs. Is that a yes?
Momentarily, yes.
And then you have handcuffs in your, I believe it was your left hand, right?
Correct.
And you have your taser in your right.
Yes.
You didn't put your taser away in an attempt to pull his hand down from the hood, did you?
I believe he took his own left hand off. Not 100% sure without rewatching it, but no, I did not put the taser away because that was the first method of defense.
That would have been a less form of physical control or use of force if you had put the taser away, grabbed his arm, and pulled it behind his back. Is that fair?
If it had worked, yes. Okay. But the problem, too, on a hot deal like that, people start getting slippery. It's hard to maintain grip. And a lot of times it's hard to get somebody in cuffs, even if you have two officers.
May I have one moment, Judge?
A lot of this dead airspace that you hear is Ferman just continuing to narrate and establish credibility and a connection to the jury while Makepeace is looking at his notes trying to figure out what he's supposed to say next.
Putting on the screen what's been admitted as Exhibit 1 and playing from 1303.
Step out of the car! Turn around! Hands on the hood! Hands on the roof! When you're told to do something, you do it! No, I just had to make sure my kids...
You'd agree with me you didn't have any problem doing it with Miss Turner, right?
Correct.
Okay.
But on that note, she also got out of the
There's
vehicle
no
immediately.
problem.
Okay.
All right, you've answered the question.
So you talked a lot about your prior experiences. We saw the news clipping and all of that. You said you'd done or conducted 15,000 to 20,000 traffic stops.
That'd be my estimate, yes.
How many times in your career have you deployed your taser?
No, I don't have a specific number.
Is it more than 10?
I don't know. Without department records, I couldn't tell you.
Oh. I'm going to ask, moving now to Miss Alicia Cook.
Okay, you just heard him turn the page in his notebook again after he asked him that question. You've done 20,000 traffic stops. How many times do you think you've deployed your taser? I don't know. Without department records, I wouldn't have any way of knowing. Guys, let me ask you a question. Why do we not have department records for the number of times that Matthew Ferman has documented a use of force where using his taser? 20,000 traffic stops. How many times have you used your taser? I've got the department records right here, Mr. Ferman. Would it surprise you to learn that in the past 10 years that you've been issued a taser, you have used your taser on 74 different people? Would that be a surprise to you? No? Would it be a surprise to learn that among the other Melvindale police officers that you have used your taser on people 3 times more often than any other police officer employed during that period of time? Why do they not have these statistics to compare? Why does Matthew Makepeace not have this information at his fingertips? You may not know this, but the taser, when it's deployed, when the cartridge is deployed, has these little confetti. They look like confetti that comes out, but they're called AFITs, and that stands for Anti-Felon Identification Tags or something like that. Each of them has individual serial numbers, and you can take that taser and you put it on the dock and you can download the data from that taser as to how many times it's been used. So you don't have to depend on a guy filling out a use of force report. You can use the data that gets transferred in through the downloading of those tasers in your discovery. The Wayne County prosecutor has taken the extraordinary step of charging this police officer with multiple felony violations, and they've known about his conduct for years. We've been talking about it for 18 months or 2 years. And everybody has a vested interest in this guy getting convicted. Melvindale fired him. They know if they don't get a conviction, he's probably coming back to work. Everybody has a vested interest in getting rid of this guy. Everybody would have cooperated. They could have had that information if they wanted it. The only excuse is laziness and lack of preparation. Remember when I said back at the beginning of this that I would have started my cross-examination with Alicia Cook because it was fresh in his mind. It was the last thing they talked about. All of that information was fresh in everybody's brain. Now, nearly 30 minutes have passed. All of the jurors have forgotten about the testimony that they just heard. Furman's forgotten about the testimony, and the prosecutor has now had a semi-heated exchange back and forth and gotten all worked up, lost his place multiple times, got to flip through his book to figure out what to talk about. And now he revisits Alicia Cook. And I promise you that stuff is going to get missed that should have been talked about.
What were you doing prior to initiating that stop?
I suspect I was either on patrol or working a traffic detail. I don't recall exactly.
Did you have another car pulled over in front of the school?
I don't recall.
You did drive to the back of the school, though, right?
Well, the back parking lot borders a road, 2 roads, a main road and a secondary road.
Were you in front of the school, or did you drive on the road towards the back of the school?
I think I was already behind the school.
And what did you see at that time?
Miss Cook's vehicle in the parking lot.
See any other vehicles?
I don't recall. I think there's school buses back there usually.
Any other
in the general
cars?
vicinity. I don't recall.
And were you able to see who was in those cars from where you first perceived Miss Cook?
Which cars?
The Nissan Rogue, Miss Cook's vehicle.
I could tell it was occupied. You kind of see the figure of a head from behind, but I don't know who's in there, no.
And what did you do when you saw that? I mean, did you just punch in the license plate just because, or?
Yeah, the whole reason the license plate's on the vehicles is for police to run.
But this is a parked car, fair?
At a school parking lot after hours, correct?
Was it parked, yes or no?
Yes.
And you're obviously...
Well, I guess it'd be technically standing, Your Honor, not parked. It's occupied and running.
You're familiar with this area. I mean, you testified that you patrol or other officers patrolled around this school, correct?
Yes.
And after hours, what time of day was it?
I don't remember specifically without seeing the report, but it was daylight hours.
Okay.
And it was a weekend day.
You said on direct, though, that it was nighttime that, or
I
morning.
don't believe that's correct. I said we do patrol, we do extra checks there at night and on weekends, after hours. I was not working night shift, I was working day shift.
And you said it was a weekend, fair?
Yes.
And you see this car at a school parking lot, daylight, and decide to investigate it?
Correct, it's my job.
You had both of these vehicles towed, correct?
Yes, they had no insurance. They couldn't legally be driven on a public roadway.
Do you call the tow driver?
We radio for dispatch, and then they do. And then a lot of times the tow truck driver will sometimes follow up with us for a specific location.
Okay.
Especially if they can't figure out exactly where you're at, an alley or a parking lot or something of that nature.
When you say follow up with you, how do they follow up with you? Do you know the tow drivers?
Yeah, most of the police know the tow drivers and they know us, and if they're one of the more trustworthy ones, you know. Oh, sorry. Sorry, Your Honor.
Judge, I don't have anything further. Thank you.
Counsel?
What's he missing? What did he not ask? You have a vehicle parked in a school parking lot. Now, he's right. He made the distinction. It's standing, it's not parked. You got a person who's in physical control. But physical control only matters for things like DUI. Physical control does not meet the elements of a traffic violation for a person who's just sitting in a running vehicle and not moving it or operating it. Under Michigan law, having an expired registration or having no insurance does not provide probable cause for a traffic stop. So the question that he should have asked Ferman was, at the point at which you noticed Miss Cook's vehicle, what crime did you suspect her of committing? His answer might have been criminal trespass. But did you observe her driving the vehicle? No. Did you observe the vehicle moving on a public roadway? No. So what lawful basis did you have to conduct a traffic stop in the first place? Would you agree with me, Mr. Ferman, that those are not things that are illegal until they're actually on the roadway? And you cannot do a traffic stop lawfully without the person driving or operating the vehicle in front of you. And he would have said, well, having the keys in the ignition and having it turned on is operating. And you could have said, well, that's not true, though. That's not what the law says. You're the prosecutor. You know what the law says, right? Well, did you ever determine why they were there? Were they there for an after-school function? Were they there for an athletic event? Were they there for tutoring? Were they there for summer school? What was the reason they were there? Well, you don't know because you did a traffic stop and you didn't have a lawful basis to do the traffic stop. So if you didn't have a lawful basis to do the traffic stop because you didn't observe the vehicle operating on the roadway with a dead registration, then what was your lawful basis for asking her to get out of the car in the first place? This gets completely glossed over by Matthew Makepeace. And that's why he lost this case. He lost all the charges related to Alicia Cook because he doesn't understand, even as a prosecutor, constitutional sequencing. Because guess what? They never charge cops. They never charge cops for doing things the wrong way. They aren't familiar with Graham versus Connor. They aren't familiar with Pennsylvania versus Mims. I know that because I never read Pennsylvania versus Mims till after I started doing this. I'm embarrassed to tell you that, but even as a police officer and even as a prosecutor, I never had any reason to familiarize myself with that case law. Now that I have, I understand the nuance. Matthew Makepeace doesn't understand the nuance. So he doesn't understand that Pennsylvania versus Mims only gives you lawful basis for exit orders if you're on a lawful traffic stop, and this guy's not on a lawful traffic stop. So by showing that to the jury, he could pave the way to prove that the only intent he could have had was corrupt intent, because in the absence of a lawful basis for the stop, you have no lawful basis for the exit order. You have no lawful basis to use force to force compliance. None of that. That's how you get to the misconduct while in office, the assault and battery, and the corrupt intent in your closing arguments by showing that there was no lawful basis to begin with. Didn't even cover it. Didn't even bring it up. Didn't even consider it. That's why he lost the case. And so now Matthew Makepeace is finished with his cross-examination. He got his bite at the apple. Now Dennis Whitey has an opportunity to do redirect, which gives him an opportunity to clear up those things. Because this is a defense witness, he gets the last word on this.
Okay. I just have a few follow-up questions.
Yes, sir.
I know the prosecutor asked you, was it in any policy to call somebody a name, correct?
Correct.
Okay, and there's no policy that says make sure to call somebody a name, correct?
No.
There is a policy that says people should be treated with respect, though, right?
Correct.
And that's one of the exhibits that was introduced. I think it was Exhibit 9, right?
Yes.
But as part of that, that's not, if somebody's disrespectful, that's not a use of force by an officer, correct?
No.
Now, I know earlier the prosecutor stated that people in handcuffs, they must be secure, they couldn't flee. Have you had that happen in your experience?
Many times.
And what are the dangers of a handcuffed person fleeing from a scene?
They present a number of dangers. Number one, they can attack an officer, bystander. We've had them attack firemen and EMTs. I had somebody who was in handcuffs that we arrested, myself, and there was another officer present. We were walking him back to the patrol car. He headbutted me in the nose so hard I was bleeding out both nostrils and thought I broke my nose.
Okay.
They can run out into traffic. They can flee. There's a whole lot of things that can happen.
So just because a subject or a person is in handcuffs doesn't mean that all danger is over, correct?
Absolutely not.
I know the prosecutor asked you some questions on cross about the arrest of Mr. Williams versus Ms. Turner, correct?
Yes.
And why did you not use a taser on Ms. Turner then?
You mean why didn't I use the drive stun feature?
Yeah, why didn't you use any tasing function on Ms. Turner?
I had a really nice clear shot of her upper leg, and I thought I could land that.
I'm sorry, not Ms. Cook, not Ms. Cook, Ms. Turner.
Oh, Ms. Turner, I'm sorry.
I'm not talking about Ms. Cookson.
Sorry.
You didn't use a taser on her, correct? The passenger?
No.
Okay. Why didn't you use a taser on her?
Because when I gave her an order to get back in the vehicle, she complied and immediately did so. When I gave her an order to get out of the vehicle, she complied and immediately did so. When I told her to put her hands on the roof, she did. Hands behind her back, she did. She was cooperative. There was no need for force. And I don't like to use force unless I feel my safety is being placed at risk.
Okay. So if somebody's resisting, you're using force, but if they're cooperating physically,
no
they just go in handcuffs. Okay.
Correct.
With respect to Mrs. Cook, do you agree that when she complied that you stopped using all force?
Absolutely. Stopped immediately.
Now, the prosecutor asked you on cross-examination. He had still shots. We paused. We had to go over things back and forth. That took a little bit of time, a few minutes, right?
Yes.
Now, when you're out there making these split-second decisions, do you have all the time to look at still shots, see where one arm is, another guy's arm is, maybe this, maybe that? Do you have that time out there?
No.
It's a very fluid situation?
Yes.
On both of these incidents, given the totality of circumstances, do you believe that you would follow policy according to the city of Melvindale?
Yes.
Nothing further, Judge.
Counsel to the people.
Nothing, Judge.
All right, does the jury have any questions for this witness? Okay, if we can pass those to the deputy.
The biggest opportunity that Makepeace missed, Mr. Ferman, you and your counsel have gone to great lengths to explain that the reason that you maybe take a more heightened approach to the first time that things start to become a little bit tense in a traffic interaction. Would you agree with that? Okay. And you believe that that is justified based on the fact that you have found yourself in situations where not having constant and immediate total control has left you in a position where you could have lost your life. Would you agree that there's a greater potential for fight or flight and negative outcomes, not just for the defendant, but for law enforcement specifically? Because you talk a lot about your safety. Would you agree that there's a greater opportunity for law enforcement officers to get hurt and for defendants to get hurt when things escalate? Yes, you would agree with that. So wouldn't it make more sense if you did everything you possibly could to lower the temperature of every single traffic stop that you ever find yourself on? I mean, why would you ever put yourself in a situation where you're immediately going to escalating the encounter, knowing firsthand, just like you testified to this jury, that the end result could be this thing could get out of control and I could not go home today? Why is it that the approach that you take is to escalate immediately instead of just trying to cool things down as much as you possibly can and then just let him talk? Because again, it doesn't matter what his answer is. His answer could be an answer that is fine, or his answer could be completely stupid. Either way, you have introduced the jury to a different way of seeing his pattern of escalation than the one presented by Dennis Whitey. And that's going to be a problem for the jury, because you'll notice the very last thing we're going to watch about Furman's testimony is that the jury has two questions to ask in response to his testimony, because Michigan does a thing that I think is great. They allow the jury to ask questions to the defendant. Listen to these questions and listen to his response.
Mr. Furman, this is a question from the jury. I'm going to ask you to give your answer to the jury. The first question is, how often is de-escalation training revisited?
In Melvindale, I guess maybe every few years. I don't have a specific date on that.
And then the next question is, how often are the weapons training reviewed, renewed?
Yearly.
I'm sorry, let me say that again. How often are the weapons training review renewed?
I take that to mean how often do we recertify with the taser and firearm, stuff like that. It's typically done yearly per the state.
Okay. Counsel to the people, any questions based on those questions? Oh, I'm sorry, you're right. Okay, thank you, Counsel.
Nothing based on that, Judge.
Okay, counsel to the people.
When was the last time before April 13th that you did it? The taser training?
It would have been in 2023. No, I don't maintain those records. We had another officer handle that.
Nothing else, Judge.
All right, does the jury have any additional questions? Any of the jurors have any additional questions? All right, the record reflects none of the jurors have any additional questions. Sir, you can step down.
Thank you, Your Honor. Thank you,
Counsel,
jury.
your next witness.
Judge, at this time, the defense would rest.
Okay, counsel, any rebuttal witnesses?
What we need to understand about those questions were that Dennis Whitey successfully planted the seed in the jury's mind that, well, how could we expect this guy to know anything different if they don't train him on de-escalation except every other year, and he's doing 20,000 traffic stops. So you're already seeing that the jury is assigning responsibility for Matthew Ferman's behavior to the city of Melvindale, their lack of training, their policy, their chaotic environment, and they are already letting pressure off of Matthew Ferman for his conduct, which means that the effectiveness of the lawyers completely balanced over here towards the defense. The state had basically no effect, and it shows based on the questions the jury asked. I really genuinely believe that the reason that this case was lost is because the prosecutor doesn't know what he doesn't know, and he did not bring anybody to help. And I'm not going to put you through closing arguments and all that stuff. Suffice it to say this: the state of Michigan did not call a law enforcement expert witness to testify in this case. Instead, what they did was they invited several members of the Melvindale Police Department to testify basically about what they saw as the difference between what they would have done and what Matthew Ferman did. The problem with that is that even in the closing arguments that Matthew Makepeace gave to the jury, he talks about the state of confusion. He talks about the state of chaos. He talks about the policy and the problems within the Melvindale Police Department. We've documented it on this channel. Here's the issue. You cannot take a shit show of a police department like Melvindale PD, and I really mean no disrespect to the chief of police. Obviously, he knows he's got a mess to clean up. And obviously, he's there and he has a vested interest in getting Matthew Ferman convicted so he never has to deal with him again. But at the time that this was all going on, the Melvindale Police Department was an absolute mess, and it probably is still a mess and will be a mess for the foreseeable future until this chief can turn it around. What I'm trying to say is, you cannot take this thing and say, this environment created Matthew Ferman, and then say these other people who also coexist in this chaotic environment should be the standard for how he was supposed to act. Now, they should have had the Melvindale police officers testify because it offers some contrast to the jury to look at, 2 or 3 or 4 police officers all in the same environment and showing that one can operate with reasonableness and Matthew Ferman didn't, right? It does show you the contrast. But where they really missed the mark is that they didn't have a law enforcement expert in this trial to talk about use of force, constitutional sequencing, constitutionality, any of that stuff. They didn't bring anybody in to show an example of what the jury should look for to see how this stuff should have happened. And that's a real problem. And Dennis Whitey actually exploited that in his closing. Well, they told you everything that he did wrong, but they didn't give you an example of what he should have done, right? The only thing they did was say, well, this police department has this policy. The policy sort of creates a continuum of conduct. And Matthew Ferman, while his conduct might have been a little more escalated than, somebody else, it still fell within this broad continuum of conduct that was allowable under Melvindale policy. They could have had somebody come in from the MCOLS, which is the Michigan Commission on Law Enforcement Standards, and they could have had somebody testify as to what the law enforcement standards are. And because Matthew Makepeace, let me just say, and I'm not trying to be too hard on this guy, but this kid literally finished his first year of law school in 2016. Here's an article about him. He's from Canada. Look, and I don't mean any disrespect to Canadians, but look around Canadian law enforcement. They operate completely differently than American law enforcement. And while there might be only a 20-minute commute from wherever Matthew Makepeace is from in Canada to Detroit, where he went to law school, there's a world of difference in the way that these two places, these two separate countries, conduct themselves, specifically about law enforcement. And the prosecutor that prosecuted this case was literally either in high school or barely out of high school when Matthew Ferman was beginning his law enforcement career. If you watched Matthew Ferman's demeanor during that questioning, he's not rattled at all. He doesn't feel the least bit intimidated by Matthew Makepeace. Makepeace is flipping through his binder. He's not prepared. He doesn't know what he's going to say in response to certain things. And Ferman's just cool, sitting there. He's dealing with a police officer who has a 1 amp fuse, and all you got to do is trigger him. And he never pushes. He never tries to corner him. He never challenges him with tough questions. I can promise you this. If you are ever the subject of my cross-examination, there's going to be at least a few objections that my cross-examination questions are argumentative. I want to evoke a response out of you because you might piss off the judge and you might look bad to the jury. But the way that you get to somebody like Matthew Ferman is to get under their skin, is to challenge them on their worldview. Just like I pointed out with the testimony. You just think that you can do whatever you want. Oh, wait a minute. Manuals don't matter to you. You can just do whatever you want to. We all just operate on Matthew Ferman's rules and we don't even know it. You know, you say stuff like that and it doesn't matter if you get dinged by the judge. What matters is that you get under this guy's skin and you allow him to become who he is in front of the jury. And what happened in this case was that Matthew Ferman got to play a role that the jurors have no idea if it was consistent or inconsistent with his character, because the only thing they got to see was this obnoxious, aggressive person that was on all these traffic stops. And then when you get him in an environment where he's not threatened, he acts completely fine, completely reasonable, completely normal. Dennis Whitey and Matthew Ferman won this trial. I hate to say that, because I really wish I could sit here and tell you that he was convicted of all 6 counts. But these counts were lost because Matthew Makepeace has no clue, clearly no clue, how law enforcement in the United States works. And he didn't have either the support or resources or whatever of Wayne County's prosecutor to bring in an expert witness or even somebody from the Michigan Commission on Law Enforcement Standards to come in and talk about use of force. Do you guys know they allowed Dennis Whitey to describe a person sitting there and refusing to follow verbal commands as active resistance multiple times? If you look at the MCOL standard, not obeying verbal commands and sitting there even with clenched fists is considered passive or inactive resistance. And the recommended response for police officers to inactive and passive resistance is soft, empty hand controls, not what is considered to be control compliance weapons like a taser. So because Matthew Makepeace doesn't know enough about law enforcement to understand the difference between active resistance and passive resistance, he allowed Dennis Whitey to frame Alicia Cook's resistance as active. So what that did in the mind of the jury was it elevated it from what it actually was, which was passive, to active. And it allowed a justification under Melvindale policy for using a taser, because in Melvindale policy, you can use a taser for active resistance. And he did that without the state even noticing that he did it, because you've got a prosecutor here. And again, he's a young guy. I'm not saying you can just go out and pick from whoever you want that has experience, but you have to know what you don't know. This guy has been a police officer for 12 years. He has been exposed to everything you could possibly see on the outskirts of Detroit, Michigan. He has been through 20,000 traffic stops. He's been through being criminally charged by the Wayne County District Attorney's Office, withdrew his plea, beat the charges, beat termination. He's not somebody that some kid that doesn't know what he's doing is going to push around all over a courtroom. And the fact that Matthew Makepeace went in there and he made it about his credibility, he made it about things that don't matter, and he missed opportunities about showing that there was no lawful basis for some of this stuff. He missed an enormous opportunity. He should have had an expert witness in there in law enforcement tactics and use of force, explaining that holding a steering wheel and refusing to get out is passive resistance. It did not warrant a taser response. It's not active resistance. Instead, he allowed the defense to frame Furman's conduct as completely compliant with training and reasonable based on what he experienced by being dragged down the road. In addition, he didn't ask Matthew Furman, well, if you've been through all this stuff and you understand that because you've lost a close friend or a person you work with, you understand that there's a possibility you may not come home at the end of the night. Why would you not try to keep that as de-escalated as humanly possible? He didn't take that opportunity on cross, and he never mentions it in his closing. What does he say? The thing that makes him feel threatened. Matthew Furman has to be the smartest guy in the room. Well, he was smarter than you. And that's the problem, because you put him on trial because he polices by ego, and you allowed your insecurity to keep you from pushing him. I'm sorry. The prosecutor acted like he was actually scared to cross-examine Matthew Furman. He didn't look him in the eye. He's flipping through his notebook. He's not doing any of the things that you do to put a witness like Matthew Furman on their heels. He completely fumbled the ball. And as a result, Alicia Cook didn't get justice because Matthew Furman did unlawful things to her, but the only case that got convicted was the one on Jakar Williams, and that was not because of anything the state did. It was simply because the jurors could not unsee the difference in the way that Jakar Williams was treated by the other lieutenant who came and the treatment that he received from Matthew Furman. He did not draw a nexus between what do all these things have in common. They're all black people, for one. I don't know whether that matters or not. I don't know if it's a coincidence or not. And the only person who continued to get punished and punished and punished was Jakar Williams. And why is that? Because the two women were intimidated enough by Matthew Furman that they decided, I don't want any more of this treatment. And Jakar Williams is the type of dude that you can look at this dude and listen to him talk and tell, that's the type of dude that will literally lose a fight and still call you a bitch at the end of it. And that's what it's all about. It was all about ego. He missed the opportunity to talk about ego. He talked about what he found disgusting about Matthew Furman, which is that he's got to be the smartest guy in the room. What the hell does that have to do with anything? He brutalized these people when you had an opportunity to convict him of multiple felony counts, and you completely dropped the ball. And because of that, I'm not even sure he's going to go to prison. Had he been convicted by the jury of all 6 counts, he probably would have gone to prison for at least probably a year or 6 months. And the judge may still do that, but they successfully allowed the defense to frame this, at least some of this, as somewhat reasonable, because the impression that the jury was left with was that, well, Alicia Cook even said in her own testimony that as soon as she stopped disobeying commands and she complied, the force stopped. That means that the only way that you could find Matthew Furman guilty of a crime as it relates to the force used on Alicia Cook was to show that he had no lawful basis to ever get there in the first place. And that's where Matthew Makepeace completely missed the mark. So, in closing, look, I'm happy that Matthew Furman got convicted. Just completely mishandled it. You either should have not charged him or you should have charged him and tried your very best to convict him. I want to say I reached out to Ross Jones from the WXYZ7 news team, and I asked him for an interview a couple months back. His response to me was, I appreciate the offer, but I just let the work speak for itself. And I have to tell you that I admire that so much, because if it wasn't for Ross Jones and if it wasn't for his reporting of this incident, we would not know most of the horrible things that we know about Matthew Furman and the way that he treated people during his tenure as a police officer. And if it wasn't for Ross Jones, Jakar Williams would not have seen justice, and we very likely would not have seen a criminal prosecution of Matthew Ferman at all. I don't make a habit of blowing up investigative journalists. I sometimes hate the way local media gets in bed with some of the local police departments and all that stuff. Ross Jones's work deserves the highest award that can be given for his journalism. He absolutely hit it out of the park, and I believe he's solely responsible for the conviction of Matthew Ferman and for the peace that the citizens of Melvindale are going to enjoy because Matthew Ferman is no longer among the ranks of the police officers patrolling there. So, in all seriousness, Ross Jones, you deserve a pat on the back. You deserve the highest honors. Your work was absolutely phenomenal here, and you should be proud of what you do. You made a difference, and I know that's all you really care about. So anyway, those are my thoughts on the case, guys. I know this was a long video. I'm sorry about that, but I just wanted to give you a little bit of detail. We don't do this very often. It gives us an opportunity to really hammer down on some of these details that you just never really get an opportunity to go through. So thank you for checking it out. Thank you for enduring it. Please let me know what you think about it in the comments. I'd like to invite you to check us out on all the socials. I'll put up a QR code here for you to scan with your phone. That'll take you to the Linktree site where you can check us out on YouTube, Facebook, TikTok, and Substack. I hope to see you on one of those platforms in the very near future. If you don't want to follow us to other platforms, but you'd like to support the channel monetarily, I'll leave my Venmo and PayPal links both here on the screen as well as in the description. Please remember to like and subscribe and leave a comment on the video. Check out some of the other videos on the channel and leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.